And the next case is Aguilar, or State of Florida versus Aguilar. Ms. Wall, are you? How are you, sir? You wish to reserve any time?
Yes, Your Honor. I'd like to reserve 4 minutes, if I may.
4 minutes?
Yes, sir.
You may begin.
May it please the Court. My name is Rebecca Wall. I'm an Assistant Attorney General, and I represent the state in this state appeal. We're here today because the trial court abused its discretion when it denied the state's motion to continue the suppression hearing on the defendant's motion to suppress. And while it's well established that the trial court has the discretion to either grant or deny a motion to continue because of the non-appearance of a witness, that discretion is not unlimited, and the trial court can't abuse that discretion, and that's what occurred in this particular case. The Florida Supreme Court has laid out 4 requirements that must be met in order to show a valid basis to continue an evidentiary hearing for the...
Hold on, Ms. Wall.
Yes.
Why are we even here?
If the court's asking about the court's jurisdiction...
Yeah, that's what I'm asking.
I think the court can take either appellate jurisdiction or cert jurisdiction.
Well, once the non-pros was filed, doesn't that end the case for all purposes?
It should have ended the case for all purposes.
Well, it did end the case for all purposes.
Unfortunately, the trial court and the clerk of the court have not recognized that the case ended upon the announcement of the state's non-pros. There appears to be, on the part of Judge Shea, as well as the clerk of the court, a belief that in order to non-pros, there needs to be a written non-pros. So if you look at the clerk of the court's official court...
Do you know any case at all that says you have to have a written non-pros?
Absolutely not. Our position is it's self-executing. As soon as the state announces non-pros, the case has dissolved. Unfortunately, we're in a position, the state is left in a position, where the clerk of the court has recognized this as a viable case, the trial judge sees this as a viable case. In order for the state to proceed in this case, they would have to file a written non-pros in order for the clerk of the court to treat this as if it were non-pros. So we stand here today with a case that, for all intents and purposes, is a live, breathing case.
Counsel, what would happen if a trial judge made a ruling, there was an appeal taken, and the trial judge continued to make rulings when the trial judge has no jurisdiction? How would that end up?
Ultimately, it would have to be determined that those were nullities. The question is, how is that going to be determined? Now, where we stand right now, in order for the state to prosecute this case, they would have to file a written non-pros so that the clerk of the court would close the one case so that they could refile and open and start a new case. Then the state's in the very real potential predicament of selecting a jury, jeopardy's attached, starting the trial, and having defense counsel say, wait a minute, I've got this order that's a valid order now on the face of it that says that all the evidence the state has been excluded. At that point, the state has there's no remedy whatsoever for the state. So while there's an order that should be vacated because it's a nullity, it hasn't been, and there needs to be a mechanism to do that. As the state stands right now...
You say there has to be a method to do that?
Yes.
Are you suggesting that we need to write a rule that would cover that? I'm not sure.
We're not asking for a rule. I think that the precedent in case law says that. I think this court needs to inform the trial judge that the trial judge erred and anything the trial judge did after the non-pros was a nullity, send it back with the instruction that it be treated as it was non-pros so that the state can proceed with the case. There certainly is no other impediment to the state proceeding. There is no speedy trial problems that had already been waived. It's simply a matter, right now the state can't proceed on it. It's being treated by the clerk of the court as an active case that's just been stayed pending appeal. So the way it stands right now, it does require the state to file a written
I'm confused. How can the clerk treat it as an active case when there's an appeal and this court has jurisdiction and the circuit court no longer has it?
By that I mean, Judge, that it's been stayed pending appellate review. The clerk of the court has an open case that's being stayed pending appellate review, and that's the point. The state can't even proceed as if it has been null prost because the clerk of the court has an active open case. There would have to be some mechanism to trigger the clerk to close the one case so the state can refile and open a new case. And I guess and it may be a logistical, technical point, but it's a real impediment to the state at this point. The trial judge has not recognized there was a null prost, so there's been no order issued acknowledging a null prost, and the clerk of the court has an open case, granted, stayed, pending appellate review. So the state needs a mechanism to get back and try this case. So this court should at the very least take cert jurisdiction in order to find that the trial court departed from the essential requirements of the law.
How can we do that? The case has been null prost.
Well, I think this court can maintain jurisdiction to determine jurisdiction. And this court can take jurisdiction to inform the trial court that it doesn't have jurisdiction anymore. That's simply the mechanism to do that.
How about this court? Do we have jurisdiction when it's been null prost?
This court can take cert jurisdiction. This court has done it in the past in SK versus State. This court has its own precedent. In SK versus State, it was one of those a unique case wherein the parents of a victim in a criminal case were granted party status in order to bring an appeal. In that particular case, and I don't know if this court's familiar with the facts of that case, juvenile defendants, high school boys, were charged with sexually assaulting a high school girl. The prosecution decided to enter into a pay agreement with the boys, a prosecution alternatives for youth. The parents of the victim were unhappy with that. The pay agreement included, it was a pretrial diversion sort of a thing where the defendants were required to satisfy certain requirements, and if they did, a probation of some sort, the state would null prost the criminal charges. The parents brought an appeal, and this court kept jurisdiction, even though the state, according to the pay agreement, had null prost the lower court case, the trial court case. This court specifically acknowledged that the state argued at that point this court didn't have jurisdiction because this case had been null prost. And this court maintained jurisdiction and pointed out that the reason for maintaining jurisdiction is because, and as the court stated, because this proceeding involves important legal issues which would escape appellate review if the case were deemed to be moot. So this court has already taken the position that when there's no other opportunity for appellate review of important matters, that the court does have jurisdiction to do that. And I do cite to SK versus State. So the court can maintain jurisdiction. It needs to maintain jurisdiction even if it's cert petition. We can consider this, you can consider the state's appeal as a petition for writ of cert because the trial court departed from the essential requirements of law. Now, ideally, we would like the court to take appellate jurisdiction and actually address the merits of the trial court's abuse in denying the state's motion to continue. Because had the court not denied the motion...
That's a discretionary issue, isn't it?
It's discretionary and has to be, the discretion has to be exercised properly. When there's an abuse of discretion, this court certainly can send it back and undo the court's...
And what's the definition of an abuse of discretion?
Well, there certainly is case precedent in where denying the motion to continue an evidentiary hearing would be tantamount to dismissing the case. That's been considered on its face abuse of discretion.
What's the definition of an abuse?
Well, abuse is when no other court would take the same position that trial court did.
You're saying that no other court would take the position that Judge Shea took in this case?
I think no other court should have taken the position Judge Shea did, especially on the record.
Not should, would.
I think a reasonable judge, there is at least one reasonable judge out there that would not have taken this position. And because the state met all four requirements, they did everything, and Judge Shea made a point of lauding the prosecutor for doing everything possible to do due diligence to get this officer here for the hearing. The state was well aware of the requirements and well aware of State v. Humphreys when she pointed out First of all, that she subpoenaed the officer. She thought he was going to be there. The officer was still employed as a law enforcement officer, so he was still available and willing to testify. He had substantial, competent, material evidence to benefit the state because he was the only state witness. And by denying the continuance, it would act as prejudice to the state because it was tantamount to dismissing the case. And once the judge denied the motion to continue, the case was effectively dead. Either it would be dismissed by the court or the state would have to null pros. There was no ifs, ands, or buts about that.
Ms. Wall, but isn't the solution to this for this court simply to dismiss the appeal? The state will refile an information. If the trial judge takes the position that its previous order suppressing the evidence is the law of the case, the state has an appellate remedy to appeal the motion, the granted the motion to suppress, do they not?
Judge Earp, that's assuming, I guess. My prosecutor days are pretty far in the past. I'm not aware of a mechanism to, does the state file a motion for declaratory judgment on the status of the state's evidence? I mean, I'm not quite sure the mechanism to challenge. I think there's, if there is a mechanism to do that, yes. If pre-trial, pre-jeopardy attaching, the state can get the court to take some position on the state of the evidence, yeah, the state would have a remedy if the court finds again, no, it's been suppressed. But if that doesn't happen, the state is in a very real situation where it is unable to prosecute and unable to appeal.
Well, what would prevent the state from scheduling a hearing on the motion to suppress if they wanted to, and give the trial judge an opportunity to cure all these problems that arose as a result of the denial of the motion for continuance and the null process?
I guess there would be no impediment. I'm not aware of a particular procedural mechanism to do that. Thank you, Your Honor.
What would be wrong with dismissing the case and pointing out in the course of the dismissal that any actions taken subsequent to the null process are null and vacated? Can we do that?
I think this court can do that. And I think, indeed, even if the court's determination, a written opinion that designates that there's no jurisdiction and that the case, therefore, has to be back in the trial court because it has been null processed. Ideally, we would like there to be an instruction to the clerk of the court and the trial court that this case has been null processed, and at least give the state the opportunity to prosecute this case. I would like to reserve the remainder of my time.
Good morning.
Good morning, Mr. Reese.
Yeah, my name is Adam Reese. I represent Anthony Aguilar in this.
Mr. Reese, assuming we agree with your argument, what do you think we should do with this case?
Well, here's kind of the problem with this. I was trial counsel in this matter, and and it's a long way to answer the question, but let me just, if I could just set it up.
If you had been the trial judge.
If I was a trial judge?
Well, no, I'm asking the question, what should this court do with it if we assume that once the null process announced that that's the end of the case as far as jurisdiction is concerned?
Dismiss the appeal. I think that the state's option, quite honestly, had the state just filed a written null process or alternatively announced a null process at the time that the trial judge says the motion to continue is denied, speedy trial had been waived, all they'd have to do is refile and we'd be in the exact same position. Unfortunately, Mr. Aguilar would have to suffer through, if you will, another arrest based on the fact that the continuance was denied and the case was null processed and then the state refiled. That's probably what should have happened in this case. The irony of it, and I've tried to figure this out, it's a unique scenario because the state's argument on its face says that nothing that happened subsequent to the null process is effective or actionable. That being the case, we shouldn't be here right now. I should be in my office returning phone calls. But at least this is a better excuse. In the meantime, the prosecutor in the case after the judge denied the motion to continue, said, quote, "In light of your Honor's ruling, the state would assert that the hearing should go forward without my witness. The burden is, of course, on the defendant to initially prove the motion. I will be making a motion to put the PC affidavit into evidence, request the court to take judicial notice of the PC affidavit. The probable cause affidavit will satisfy my burden, assuming the defense satisfies his." When I read the case of State versus RJ, there's only one line in that case that stands out to me, and that says, since, quote, "since no judicial action took place prior to the state's announcement," referring to the null pros, "the mere intention of the trial court to accept, in that case, the child's plea, is not sufficient to foreclose the state's discretion in entering a null pros." My position before the trial court at that point was, after the state decided to go forward, it's almost given them an unrealistic or an unfair advantage of the defendant. We didn't win. We couldn't get our evidence in. So now, mid-hearing, we're just going to null pros and now start over again.
How do you, last year in Sadler versus State, we said, a null prosequi effectively ends the proceeding and any action taken subsequent to the filing of the null prosequi is a nullity.
I understand.
So whether, I mean, at that point, Judge Shea had not ruled on the issue.
Right, and that, in essence, sends me back to the point that I think that the court needs to just dismiss the appeal. The state should have, in essence, just null pros at the time the judge denied the continuance.
We could dismiss the appeal, or we could write an opinion that says Judge Shea didn't have any jurisdiction to rule on anything after the null pros was announced.
Which sounds to me like the only way to get this cleared up, because otherwise you all are going to be back here again when Judge Shea says it's the law.
You know, he may, excuse me, I'm sorry. He may come back with the same ruling he had before, even though he didn't have jurisdiction, assuming that we buy your argument. But at least you'll have another shot at it. Or the state will.
I think, and I think Sadler's also a little bit different than the case before the court in certain respects, because that was withdrawing an announcement of a null pros and trying to proceed because now the witnesses had been found.
Yeah.
It's kind of a different scenario than this specifically. And I'm sorry, go ahead, Judge.
Would you agree with opposing counsel's assumption that you don't need a written order on once the prosecutor announces that this case is being null pros, that's the end of it? You don't need a written order
Although
on
at
it?
the time of the hearing I said a written null pros should be filed.
Well, it should be filed, but it does. That isn't
I
what.
don't think so. I think as soon as the state says it's null pros, it's null
It's null
pros.
pros.
However, at the same time, it's kind of interesting, and I'm not trying to, get incredibly hyper technical with this issue, but it's kind of, I guess, legally entertaining. If, in fact, the state had sworn in their first witness on a non-jury trial, they couldn't null pros it because jeopardy attaches.
Right.
The same scenario, as soon as the jury is sworn, jeopardy attaches. Here, the state chose to proceed. They chose to. They basically created a situation where we had to proceed, that we put on testimony, and then when they realized the last-ditch effort to go ahead and save their case, there was no way to do it because the motion was going to be granted because there was no evidence to determine the case otherwise because the officer failed to appear. And that's interesting in and of itself because people get subpoenaed all the time. That's a court order. It's not an invitation to appear. Apparently there was communication, there was an email, there was a deposition where they actually spoke about his need to testify a few days later at the scheduled motion to suppress, and there was no explanation as to why the witness wasn't present. Their cell phones, people can get in touch with anybody all the time now. This is not like even 10 years ago. This officer or deputy should have advised the court, I'm in traffic, I can't make it, there's a medical problem, anything to let the state know what's going on. But unfortunately, that's not what happened, and the state gave no explanation for the officer's absence or any assurance.
I can conceive of a lot of situations where they would be trying to get a hold of this witness and be unable to get a hold of the witness. The witness may have a legitimate reason for not being there. We don't know. But the point is, the witness wasn't there. They decided to null pros it. That's the end of it.
Well, it should have been null pros, I think, before any testimony was taken or they engaged the act of the court. And that's only from my reading of RJ and what that statement is, that due to the fact that judicial action in our case had taken place.
I apologize. I didn't hit that time clock when you got started, but I think
Am I finished?
time's about up.
Okay, that's all right. I guess under the circumstances, I'd ask the court to just dismiss the state's appeal for lack of jurisdiction.
I think we seem to be coming to a consensus about dismissing the case. Now let's just see what else happens.
Judge, the irony is that at the trial level, we wouldn't even be here if opposing counsel hadn't taken the position then that there had to be a written null pros and got the judge moving with him here.
So
and
we should hold him in contempt?
Acknowledges it now.
We're not going to blame opposing counsel.
Not now. No. But I also would argue, I take umbrage to the argument that the state forced the defense to do something in this case. The rule requires that the movement in a motion to suppress initially make a showing. So the fact that the state just asked the court to follow the rule, it wasn't the state forcing the defendant to go through some, testimony. It was his burden anyway under the rule. So I take umbrage to that. The state isn't required to announce a null pros at the beginning. The state had every right to see if the judge would grant the motion to continue. The judge denied it, and the state had every right to try to salvage the case because there was only one way that case was going to go. It was going to be gone. Either the judge was going to take all the evidence away or the state was going to null pros it. So the prosecutor had every right to try any option possible to save the case. There seems to be some sense at the trial court level that there's some judicial economy to null prosing a case when there's a little problem in the case. I see it all the time. I'm sure this court sees it all the time. If for any reason that the state can't fulfill the procedural requirement at the time, the courts look to the prosecutor to do the right thing and null pros the case. Why that would be more judicially economical to dismiss, file it again, recharge, rearraign, rather than continue for a couple of weeks is beyond me, but I see it all the time. In this particular case, the prosecutor did exactly the right thing. Moved for a continuance at the very beginning and put the court on notice that the witness wasn't there. Then asked the court to at least hold the defendant to the burden of the motion and tried other ways to comply with the hearing. When that wasn't possible, the prosecutor did the last possible thing, waited to the last possible minute because that was the right thing to do. It was judicially economical to do that. And the state should not be punished because they tried other alternatives. The court should, at the very least, issue some sort of instruction to the trial court and the clerk of the court, acknowledging that the case was dismissed at the announcement of the null pros. Allow the state to go forward with this case. Thank you.
Thank you.